Thank you everyone for joining us in what is the first in a series of webinars focusing on contentious issues for life sciences companies. There will be details coming out soon for the next webinars in the series, so please do keep an eye out for that and join us for any that are of interest. My name is Paul Glass. I'm a partner here at Wessing and the head of the cybersecurity practice. I'm joined today by Vin Banj, who's the head of the data protection practice here at Wessing, and Jesse Prynne, an associate in the disputes and investigations team. For the first webinar in the series, we're going to talk about cybersecurity risk for life sciences companies. And this is a topic that we've chosen because we've particularly seen life sciences companies targeted in the last couple of years, sometimes leading to significant loss of intellectual property, confidential information, and or personal data. And we're going to focus primarily in this webinar on sort of external threat, but many of the issues and mitigations we'll talk about are also equally applicable to internal threats such as employees, human error as well. So what we're going to talk about today, Vin is going to talk first about the legislative and regulatory background. I'm then going to talk about why life sciences companies are targets for hackers and attackers. Jesse is going to talk a bit about responding to data breaches and cyber attacks, and then I'll finish with some of the steps you can take and things to think about to prepare for cyber attacks and to mitigate risk. And then we'll have some time for questions at the end, so please do send those in if you have any. We'll talk a bit today about legal and non-legal issues, and the reason for this is that I don't think you can quantify, manage and mitigate the business risk arising out of cyber and data loss without understanding, so yes, the legal risks in the background, the legal framework, but also the commercial risks and what might go wrong. And that's why some of our own legal team in this area also have a good understanding of the technical issues and sort of hacking as well. So enough from me, onto the substantive part of the webinar. So first I'm going to hand over to Vin, who's going to talk about the legislative and regulatory background.
Thank you very much, Paul. It really should not be a surprise that when you talk about cybersecurity risk, then the words data or personal data are often very close by. And in fact, therefore, the topic of GDPR becomes very close by to that topic, if not core and rather central to that particular discussion area. So what I wanted to do just today is just to set out the sort of core scene around data and GDPR, so you can keep that context in mind as we start to then expand this topic out into the areas of cybersecurity itself. Now, we can't do the whole topic of GDPR justice in just a few slides, and particularly in this introductory way. So we do have a lot more resource on almost every bullet point that we cover today in much more detail, and in some cases with webinars that focus purely on those discrete points. That's all available on our global data hub, which is our microsite that talks to all things data protection, cyber and security. And there you will find more content, thought leadership, as well as our virtual bank of learning through our webinars. But I'm sure many of you will be aware that the GDPR entered into effect on the 25th of May 2018. It's been around for a year. And it's a law that we've seen a lot of activity on over the last year. In the UK, we've seen a lot of activity as the GDPR has been implemented and expanded on to a degree through the UK Data Protection Act 2018, which received royal assent on the 23rd of May this year. And we've also seen how other countries across Europe have implemented the GDPR and added their own local twists and turns and interpretation, and indeed derogations in some cases around the GDPR. So it's far from the one harmonized uniform law that we thought it might be, and we thought was promised when the consultation, the initial dream of GDPR came to play. So it's still very much an area where the GDPR itself is the core substantive law, but you do still need to look at the relevant country legislation as well. You'll see, as I just focus for a moment on the UK Data Protection Act 2018, there are some substantive elements which then begin to expand over and above what we see in the previous legislation. You start to see areas such as digital consent, derogations around areas such as special categories of data, and I'll talk about special categories in a moment. Also the rights of data subjects and exemptions around being able to use the data and so on and so forth, the whole environment. That's very much part of the UK Data Protection Act, and that's in Part 2. And then, of course, we see the duties and powers of the ICO in Part 5. And whilst that's very much aimed at the duties and powers of the ICO as a enforcement machinery, if you like, and the lead regulator, what we are seeing is the codes of practice, for example, that are being issued under this power are becoming much more influential and much more determinative, and actually provide a source of interpretation as well. And then, of course, there is an element that deals with enforcement, and we see a replication of the liability and the fine, the replication of the sort of 2 and 4% that we see in terms of fines that could be levied against your global annual revenue. And we also see the introduction of various offences, and some of these strike at the very heart of the type of data processing activity that you see within the life sciences context. So offences around the re-identification of anonymised personal data, where that takes place without the consent of the data subject, or trying to get around the disclosure requirements under a subject access request, and particularly in cases of altering that data, you could again find that you're falling foul of some of the new offences under the UK legislation. So it's just examples of how countries, and certainly the UK, begin to add and slightly depart from the core law as we see it under the GDPR itself. Now, I mentioned a moment ago that we have the context of special categories of personal data, or sensitive personal data, as we read under the old data protection regime. And it's when you start to look at the definitions, you begin to see that when there are references, as we put in bold on the slide, to genetic data or data concerning health, you soon begin to see that this very clearly falls under the realms of special categories of data, which is so important and so integral to a sector like life sciences. And you can read more about that in terms of Article 9 of the GDPR that begins to elaborate on that. And it also does in terms of the restrictions that then begin to apply in processing special categories of data, so genetic data and data concerning health is, and this is the starting point, it's prohibited unless there is a legal basis for this. So it's really important under this new regime of GDPR that you assess the data processing activity, and there is the concept of record of processing activity. And this is assessed against the context of the specific purposes, which have to be matched against the specific legal basis against which you hang your hat to say this data being processed for that purpose is therefore lawful, and this is the assessment that we've been through. Otherwise, you could find that you're falling foul of the regime set out in the GDPR and replicated into the Data Protection Act 2018, and you must be able to demonstrate that, and that is one fundamental difference between the old law of data protection and the new regime under GDPR, in that there is now a front-line obligation of being able to demonstrate the steps you've taken to ensure compliance. So it's a very, very different regime to the old one. I mentioned a moment ago that there are also, within this regime, there are rights, there are obligations under the GDPR, as we saw under the old law. And I'm not going to go through these in detail, but just to highlight below that, what you see on the slide there is that these are some of the core and fundamental rights that all data subjects have. So as an organization within the life sciences industry, how you process the data has to be set out and has to be capable of being operationalized in the context of data subjects being able to exercise these rights. And if you can't, then that's when you begin to rub up with some of the tensions that could lead to non-compliance and the potential risk of those hefty fines that I mentioned a moment ago. But also, these are the sorts of rights that you could find that begin to erode your asset value, if your asset value is the data itself, and actually begin to create, to a degree, asset risk. And the degree to which that's created depends on the degree to which your GDPR compliance program has actually genuinely taken on board some of these key points of GDPR framework that I've mentioned. And also beginning to sort of highlight the point that data isn't a concept of ownership from a data protection law perspective. It's really one of guardianship and responsibility, and it's one where it very much will impact on your ability to say this data is mine and mine only. The law actually says something different, and that's why GDPR really does come into play. GDPR goes further and starts to talk about concepts which were not mentioned before, and these start to play more into the area of security and cyber in particular, because you'll start to see more references in GDPR around data minimization. You'll start to see more references about anonymisation and pseudonymisation. So this whole key coding concept, which isn't necessarily new, but is new when you look at the source of data protection law now under GDPR. So we'll now find that actually as you move through and get deep dive into the obligations under GDPR, you begin to see that there is more of a focus on protecting data, more of a focus on data security and minimizing the data and minimizing the risk to the data, and recognizing some of the concepts such as anonymization and pseudonymization and what they actually mean and how they apply. So unlike the old law, under GDPR it's very clear that there is no silver bullet of consent or standard policy that can actually get you through this particular journey. You need to make sure that you've looked at the obligations of GDPR and you've actually operationalized that robustly. And there is a frontline compliance obligation that has a sting to it, because that's really the area of the 2% fine regime under the GDPR. So everything you hear about impact assessments and record of processing activity and requirements to assess the parties, whether you're a controller or a processor, that you're sharing the data under a data sharing protocol, these are not terms that should be taken lightly. They are obligations under the new framework around how you handle the data, much of which also focuses on how you understand what data you're holding and why, but also the measures you take to keep it secure. So security remains a key component of GDPR legislation. And there is a complex formula which becomes more complex if you don't operationalize and deal with the issues under GDPR correctly. So just a brief introduction, as I mentioned, and we have more information on all of these topics available, and we'll point that out again towards the end of the webinar. But hopefully just to set the scene that this is very much a regulated area, and it is very easy in terms of the type of data that we see in the sector for it to be caught by the GDPR, and for those GDPR obligations to flow through all the different parties in the chain, whether it's upstream or downstream, around how the data is handled. And it's the link between personal data, the data per se that organizations hold, and how that perhaps manifests itself in other aspects of IP and assets, which become often the source of the risk under cybersecurity. And this is where perhaps I hand over to Paul to talk a little bit more around why this matters more from a cyber perspective in this context.
Thank you, Vin. And one of the reasons we sort of go back to GDPR in relation to personal data, at least in the UK, is that we don't have sort of equivalents of HIPAA in the US or that sort of health sector specific legislation. And so there is some sort of NHS digital guidance around data security and that kind of thing. In reality, it all refers back to sort of underlying data protection legislation when we're looking at that aspect of it. So what I'm going to pick up now a bit is why life sciences companies are targets for external attackers and what those threats are. And the reason for covering this early is we fairly often hear the refrain from companies that they don't believe that they would be a target, or they don't understand who might be targeting them or why. And this is particularly the case with smaller or younger companies. And understanding why you might be a target is an important factor in considering the risks surrounding your data, what security you should have in place, and therefore the risk that attaches to the data that you hold. Now, for life sciences companies, as you'll know, and particularly sort of biotech, but across the whole industry more generally, it's often the case that a lot or even most of the value in the company is in its intellectual property, its technology, or its data. And this is even more the case now with the revolution in sort of digital health that we're only really at the start of. At the same time, in our experience and research, sort of indicates that, say for what you might call big pharma, while life sciences companies are IP and data rich, you might call them sort of security poor. And there are plenty of examples of compromise of networks for theft of data or loss of healthcare data in the public domain. And I've referred on the slide there to one of the bits of research in the US, and this is the healthcare sector as a whole. But from 2017, research of the US Healthcare and Public Health Sector Coordinating Council showed that whilst on average across all sectors, the average spend on on sort of cyber and security as a proportion of the overall IT budget is between 10 and 14%. In the healthcare sector, it's half of that. It's sort of between 4 and 7%. And so that does sort of match up with our experience that fairly often companies in the life sciences sector aren't as secure as they perhaps could be and against other companies. So given the nature of the data that life sciences companies hold, the way the sector operates, and does what appears to be sort of degree of underinvestment in security, does mean that the sector is considered by attackers and criminals as a good target in terms of risks and reward. So we're going to talk a bit now about sort of what the main external risks are. And the first of these, which is probably the first one that springs to mind, is intellectual property theft. This is a substantial risk across the sector. In the past, and frankly, we see little sign of this changing. It tends to come from certain specific jurisdictions where companies in those jurisdictions are trying to play catch-up in terms of their capabilities for research and development. And those are also jurisdictions where minimizing the risk of use of or chasing down stolen data or of even obtaining damages following data theft is very difficult. And this isn't an uncommon issue. We do see it happening. There's plenty of research in the public domain about it. And that means that life sciences companies should be making themselves as hard a target as possible. The second risk is really sort of theft of personal and medical data. We appreciate this is more likely to be relevant for some of you who are doing sort of perhaps trials where you actually hold more of this data. And to be honest, the risk is more focused on the US healthcare sector. But to give you an idea of why this data is an attractive target, currently sort of full profiles of data subjects which have been stolen through breaches of healthcare providers sell for the most money on dark web markets, and this is by a very, very wide margin. It's not even close to the second. It's a multiple of sort of 7 or 8 times the value per record. So that sort of medical record full profile of individuals is a prime target. As I briefly mentioned before, it would be remiss of me not to mention sort of insider threat, which can be either deliberate theft of data or accidental data loss. The employee who goes out for a drink on a Friday after work and leaves their laptop in the pub or have a phone or laptop stolen. We're not going to dwell in detail on this today, save to note that some of the sort of mitigating actions that can be taken that I'll talk about later do apply equally to this area as well. One of the other things that we've seen a lot of activity recently is on ransomware, and the two sort of main varieties of ransomware I want to break that down into. The first is, as everybody will be aware of, the sort of WannaCry type incident that hit the NHS very heavily a couple of years ago, although actually that malware wasn't ransomware, it was actually just data wiping disguised as ransomware. And this is locking computers on a network, usually with malware that locks individual computers but spreads very quickly across the network, and you get a ransom saying, for each one, pay 350 euros worth of Bitcoin and we'll unlock your computer. And the latest variants of this type of malware do spread very, very fast across the network, usually by using some exploits which were unfortunately stolen from the NSA in the US a few years ago. They are now into regular commercial use. Commercial, I mean criminal commercial use. And as an example of this, you'll have seen in the US in the past couple of weeks that 2 US city authorities have paid $1.1 million in ransom to have their IT systems unlocked. This one's been in the news because the public body nature of the victim organisations, they have to declare that they're using effectively public money to the extent that it's uninsured to pay this sort of ransom. And again, you may have seen Norsk Hydro a couple of months back were infected with ransomware. They elected not to pay. They are still dealing with the clean-up, and it was reported last week that their costs are around £45 million and still increasing. There is a lot of this activity going on. Cyber liability insurers are reporting significant increases in claims of ransomware. And one legal issue I want to put out here to consider is what would you, so a technical issue that leads on to legal issues. What would you do if your network was subject to ransomware? What are your recovery plans? How quickly can you restore from backups? And how much data might you lose in going to the last backups? That's the sort of commercial risk aspects. Looking at the legal side of it, what might the effect of that be on your ability to meet contractual milestones? Have you considered whether ransomware would fall within contractual definitions of force majeure? This hasn't really been considered much yet by the English courts. Force majeure is usually defined as an event beyond the control of either party. And that brings in the question of whether the victim business had adequate protection in place against the ransomware attack in question. To use the GDPR language around security, did the business have adequate technical and organisational measures in place to ensure the security of data? This hasn't been tested under English law yet. I very much expect that it will be tested in the reasonably near future. The second area I wanted to pick up in terms of ransomware is that we've seen quite a lot of is the theft of data with blackmail that then follows. So this is attackers obtaining access to networks, usually via phishing emails, moving laterally within the network, stealing large amounts of data, and then demanding payment in cryptocurrency for the hackers not to release into the public or sell the stolen data. We've had several clients of ours targeted in this way in the past 2 years, and we know of tens, probably now into the hundreds of others, through activity that we've done for clients on data recovery and analysis and working with UK and other countries' police cybercrime teams. And this is, it's becoming more and more common, and it puts the company in a situation of knowing that some of its data, often highly commercially sensitive, is out there. That data will not necessarily belong only to the company, because typically for life sciences companies, you'll have collaboration and license agreements, drug development agreements, where you have not only your own IP and confidential information, but also the IP and confidential information of your partner. And that will be subject to contractual confidentiality obligations, and I'll come on to that in a minute. One point just to mention now while we're on the topic is I referred to police cybercrime teams. If you do find yourself in this kind of situation, the police cybercrime teams and the National Cybersecurity Centre, the NCSC, will get involved and will provide actually now very good support. And one message that the NCSC is very keen to get out at the moment is that they will, when they are supporting a business who's been the victim of a cyber attack, they will not pass information on to regulators. And they're absolutely explicit about this because they've had feedback that businesses are worried about involving the NCSC or the police because it means that the authorities are seeing all their dirty laundry. They don't want that passed on to the regulator. That doesn't happen in practice. There are issues to manage around privilege, legal privilege, but in our experience, police cybercrime teams and the NCSC are sensitive to this and do mostly understand it. Another issue that we've seen a reasonable amount of is cybersecurity risk around M&A activity. We're not going to go into detail on that here because it's an entire talk in itself, but in sectors where there is extensive M&A activity, like the life sciences sector, cyber is a particular risk. And this can be anything from, is the IP in the company that you're buying worth a lot less than you think it is because it's already been stolen and used elsewhere to develop similar products? or have there been data breaches within the company relating to personal data, for example, that don't get uncovered during due diligence, and again impact the value of the acquisition. That's an issue across all sectors for M&A, but it is particularly a problem in the life sciences sector. One final point to flag up here is when we refer to breach or cyber attacks, people tend to automatically default to data theft or data loss, and that's impacts on the confidentiality of data. We're really talking about confidentiality, integrity, or availability of data. And just as an example of that, we've seen a situation where code designed to randomize trial results was inserted into a company's computer software by a disgruntled employee, and that rendered trial results effectively useless. A non-availability is a third party reliant on access to data that you hold in real time, such that if that data is no longer available because you have a ransomware attack or it's stolen and deleted, losing access to that data causes a third party loss. Now, appreciate again that's slightly less likely in the life sciences sector than, for example, financial services. But I think as we see greater sort of chains of data management and data being used for more extensive research in the life sciences sector, we can see this becoming more of an issue. So hopefully that should give you an idea of why life sciences companies are at risk. Jessie is now going to talk a bit about responding to data breaches.
Yes, thank you, Paul. So as Paul said, I'm going to talk about how you should respond to a data breach in the event that one occurs. First of all, a cybersecurity breach should be treated as a crisis management event, which may sound obvious, but the point about this is that your ability to coordinate who is responsible for managing the incident internally, who you are going to instruct externally, establishing the precise extent of the breach, what you need to do, who you need to notify about it, all has to be done, and it has to be done as quickly as possible. So having a preferably practiced crisis management approach is important. It may of course be that because of the nature of the breach and the services that it's affecting, so where, for example, as Paul mentioned, IT systems are locked, this in any event forces a crisis management response where the organisation can't continue to function as normal. Priorities for your response will include verifying the breach and containing it, confirming the extent of it and the data or services affected by it, and then identifying the risks arising to the business and others from it. In order to do this, you're likely to need to instruct external forensic IT support, as well as legal advisors. And just one point which Paul touched upon, which is privilege. So regulators cannot require disclosure of privileged materials. There have been some quite interesting and significant decisions in the past few years relating to privilege as concerns internal investigations that organisations undertake. So just to cover this, by way of, I'm sure, a reminder for most of you, legal advice privilege attaches to confidential communications between a lawyer and a client for the purpose of obtaining or giving legal advice, whereas litigation privilege attaches to confidential communications between a lawyer, client, and either of them and a third party, where those communications are created for the dominant purpose of obtaining or giving legal advice in relation to actual or contemplated litigation, or for the collection of evidence. In May 2017, the High Court handed down a decision in the SFO and ENRC litigation, where it was held that in relation to documents created but in an internal investigation carried out by ENRC having been alerted by the SFO to potential allegations against the NRC, that neither legal advice or litigation privilege attached to those documents. And the finding in respect of litigation privilege was that because the proceedings in contemplation were criminal proceedings, which required a higher standard of proof than civil proceedings, the litigation was not actual or contemplated. Also, in terms of the dominant purpose, the court found that it was not the dominant purpose was not made out because the documents had been created for the internal investigation to help ENRC prepare for an external investigation by the SFO and find out what had happened. I should say that these documents included interviews with employees, but also included forensic accountants' work product, which is analogous here to forensic IT support. That decision was overturned by the Court of Appeal, and in certain respects, including in respect of the dominant purpose, which means that the court found that obtaining advice and assistance in order to head off, avoid or settle contemplated proceedings was protected by litigation privilege. And the important application points from this is that you have to ensure that there are contemporaneous, or it certainly helps to ensure there are contemporaneous records to support the assertion of litigation privilege over documents being created for an internal investigation. And also sending out litigation hold notices and such like will help. Where a forensic IT consultant is therefore instructed at the time of data breach, you are more likely going to be able to support the fact that this is because of contemplated proceedings. Obviously, the data breach has happened, you need to establish the extent of it, and out of that may flow regulatory and potentially civil proceedings. Where the area is still tricky in terms of involvement of forensic IT support is where there hasn't been a cybersecurity breach, so where you may have support in terms of doing penetration testing for preparation against such a breach. In that situation, at present, with seeking to establish legal advice privilege, our view would be that it assists to have legal advisors instructed both to assist with the instruction of the IT forensic firm as well as the dissemination of their advice. As I say, for litigation privilege in an internal investigation context where there's been a cybersecurity breach, it's likely to be easier to establish that that applies, but it does help to have solicitors involved and to keep contemporaneous notes that litigation is in prospect, which is why the investigation is being undertaken. Once you have begun to get a sense of the scope of the breach, the next point to be considered is whether you need to notify the regulator. And here, obviously, in the UK, that will be the ICO. You'll also need to consider whether it's necessary to notify data subjects. In terms of the ICO, the requirement under the GDPR is to notify unless it is unlikely to result, unless a breach is unlikely to result in a risk to the rights and freedoms of individuals. The notification has to include various details, which is where it's helpful to have IT forensic support in order to be able to get all the details you need for the notification, and that has to be done within 72 hours, so 3 days. In terms of data subjects and notifying them, this has to be done without undue delay where there is a high risk to the rights and freedoms of individuals. So that is a higher bar. As Vin referred to, medical data, medical and health personal data is a high-risk area. And if compromised in a cybersecurity breach, it's highly likely to require notification not only to the ICO but also to the data subjects. There can, I'll just mention briefly, be challenges in terms of identifying data subjects, which can require the use of document review platforms to try and work out if personal data has been compromised, if it's possible to identify data subjects from that personal data, and if therefore they should be notified. Also, it's just worth mentioning that life sciences companies can, of course, be subject to other regulatory requirements. So, for example, for companies registered with the Care Quality Commission, they are subject to the Health and Social Care Act 2008 Regulated Activities Regulations, which require that the holding of records and systems and processes support the confidentiality of those using the service in question and meet data protection legislation. At present, that refers back to the GDPR, so in effect by complying with the GDPR, you will be complying with the Care Quality Commission regulations in that regard. However, it's worth keeping in mind that you will also be subject to their regulations in terms of cybersecurity breaches and what actions you need to take in that regard. The CQC also requires its regulated service providers not only to comply with the GDPR but also with the National Data Guardian's standards. So those are the standards that Dame Fiona Caldecott has looked into at various reviews. Finally, I'll just mention that as well as your IT forensic support, your legal advisors, it's also likely you will require PR communication support, and communication support with cybersecurity experience is critical. Turning then to the other aspect or another important consideration for life sciences companies, and that is data contracting. So as has already been touched upon, life sciences companies often enter into joint venture type arrangements. These are very common, be that by way of licensing agreements, supply and manufacture agreements, etc. And these agreements are likely to cover, among other things, the scope of rights being licensed, the purposes for which the data can be used, ownership of the underlying rights and rights to derive data, as well as warranties of compliance with laws and regulations such as data protection and confidentiality provisions. We would recommend that the obligation to keep third-party data confidential is preferably done on a reasonable endeavours basis, or with slightly more onerous, a best endeavours basis, but that an absolute endeavours basis is avoided. The important point is to be aware of the third-party information rights if you have a breach and how you manage that information flow. It is fairly common for these types of agreements to include confidentiality provisions, which mean that any third parties with whom you contract, so subcontractors, sub-licensees, have to enter into equivalent confidentiality obligations. There's also a question about the degree of care with which the confidential information is managed, and there may well be notification requirements set out within those agreements that, similarly to the regulatory requirements, you have to notify the third parties, counterparties, with undue delay where a cybersecurity event has occurred. So these are the various factors that life sciences companies have to consider in responding to a data breach. And of course, the preferable situation is that a data breach is avoided altogether. And I'll hand over to Paul, who's going to talk about some of the ways in which that can be achieved.
We'll aim for achieve, but I think we'll go for more about mitigating risk at this stage of things. So, I mean, the starting point here, to be honest, around reducing risk and preparing it is understanding your data. And just to pull out a few points here, so effectively this starts with one of the key issues is data classification. And this is understanding what data you have within your organization. So you'll have, for example, data in your laboratory information management system. If you use it within an electronic laboratory notebook software, and then you'll have HR data, you'll have non-sensitive commercial data, you'll have sensitive commercial data, you'll have your own intellectual property and commercial data, and as we've touched on already, the commercial data and intellectual property of third parties who you're collaborating with or manufacturing for, or who are manufacturing for you. And the key here is considering these different types of data, considering the risks that attach to those different types of data, both business and legal, and having appropriate processes and measures within the business to manage the risk that attaches to that data. And so that really does go to that high-risk data, and then how do you and how should you protect it? The second issue is how does data move within your organization? And this involves looking at questions like, do staff do things like extract data from your LIMS or elsewhere and save it into SharePoint, for example, email it around? how does data move inside and outside your organization? And it's important to have a good understanding of what inside and outside means. A lot of life sciences companies still, to some degree, haven't shifted to cloud. But cloud, the best way to think of cloud, whatever your implementation of it, is basically somebody else's computer. So having a proper understanding of what is inside and outside the corporate network is very important. And the issue here really is, how does data really move? And this is not how your policies say it should move, because employees never ever follow policies as to what they should be doing with and how they should be managing data. But actually having that understanding of how people access, transfer and utilize the data within your organization, and thinking about appropriate security that you can put in place around that still allows good behavior but also restricts bad behavior. And when I'm talking about bad behavior, you can pick up examples like the classic one of a major listed company in Sweden that had policies preventing the use of Dropbox, etc., and a fairly well-known incident where the CFO decided, just because it was easier than remoting in from home, because he had some connectivity difficulties, that he just dumped a load of financial information in Dropbox and then accessed that from his home computer. That kind of behavior should be prevented by policies and systems, but equally you don't want to move too rigid so that there's too much friction within the business. And this again applies to the high-risk data, identifying what it is, whether it's IP, clinical trial data, medical, personal data, understand how you can operationally protect it, but still run the business and not create too much friction. I've referred in that to IT policies. IT security policy will be the main policy for these purposes, and you should absolutely have one of those, but you also need to think about things like acceptable use policies, privacy policies, that all form that part of suite of policies that touch on information security in some way or another, should form part of the staff handbook and that staff sign up to when they join, and this means that staff then understand the standard that they should be operating to. You should absolutely have a specific breach response plan, and this is separate from your BCP, your business continuity plan. The National Cybersecurity Centre actually last week has just published some useful guidance for small to medium-sized companies for developing breach response plans, and they've got some historic guidance for larger companies, so I would absolutely recommend looking at those on the NCSC website. And the important thing here is the plan should be tested at least annually with full sort of live tabletop exercises, and then a post-mortem afterwards, and changes made to the plan as necessary. And a tabletop exercise is effectively a live fire simulation. You have all the relevant people on your breach response team within the room or within the business, and all working on the same time for half a day on an unfolding scenario that they don't know what it is. You have either somebody else within the business or external providers tasked with running the exercise, and this is invaluable in seeing how the breach response plan works, how people followed it, how people didn't follow it. It means you can see how people respond in a highly pressured situation and can think about, actually, is that person the right person to have on the breach response team? It means that if you do have a breach and you're in a highly pressured situation, the team aren't doing it for the first time. And that's probably the greatest value out of this. And we do help clients run these exercises at times. This should be standard practice. We're amazed at how often it still isn't, but there should be at least annual, preferably 6-monthly penetration tests or red teaming exercises, however you want to call it. But an external party, third party, contracted to effectively attack your systems and try and break in. And this should be a carte blanche, try and break into our systems, not a please attack this narrow IP range and see what you can do when that narrow IP range is the small part of your network. That just isn't enough anymore. It's not sort of accepted as good practice within the industry. There are a lot of standards out there that you can use for information security. I've put ISO 27001 and NIST 800 is the relevant standard. They're quite a lot of work to comply with, and they certainly don't guarantee you won't be the victim of a breach. I've seen plenty of businesses that have ISO 27001 and then have a data breach, but they are a good place to start, even if you're not actually going to go through full certification and get the standard itself. But going through those and applying the principles within the business is a very good starting place, and obviously you consider later on whether you do want to go down the route of getting full certification. I've already referred to the NCSC website as a great source of information for preparing for and responding to breaches. The last thing I put on this slide is that you should have a director who is responsible for understanding and managing cyber risk. And this doesn't need to be somebody who is an expert in security. It needs to be somebody who knows enough to understand the risks and the posture that the business is taking around security, and ask appropriate questions and challenge the IT and the security function, and also to deal with cyber risk as a standing item at every board meet on the agenda for every board meeting, and it should be a standing item on the agenda for every single board meeting. The next slide, this is just sort of a starter for 10 on reducing risk, and as I said, I know I've added number 11, I'm a lawyer, not an accountant, I can't count. This is really just things that you should be thinking about, and this applies to a lot of companies, but also it's slightly more tailored to life sciences companies. This comes from an American PHA publication on specifically managing cybersecurity risk. It's quite useful. It's large. I'm not going to go through it in detail here. It's a list of things to think about. If you're the director or senior exec or head of legal tasked with responsibility for cyber risk from a business perspective, have a look at these issues a bit more online, or if you just want to freak out your head of IT or security, just ask them what they're doing to manage endpoint risk or how you're dealing with network security risk or something like that, and they'll wonder what on earth you've been reading. The last one I've added here is staff training. This is key for a couple of reasons that I'll get onto in a minute. It's now common, even standard practice, to have at least 6 monthly, preferably more often than that, staff training on cybersecurity issues. It's not enough anymore to simply deal with it when you onboard new staff. It has to be more regular than that. Running quickly through because I'm conscious of time, and we've got a few good questions coming through actually. I've talked about identifying the key data and protecting that the most. Part of that is the issue of who needs access to that data, when do they need access to it, how do they need access to it. This is an issue across a range of industries, but we've seen it perhaps more often in life sciences under the sort of guise of, oh, but somebody within the business might need access to that data one day. And so there's often even no access control, sometimes in our experience. The reality is that often people working on Project Alphabet will have no reason to see the data or information in relation to Project Zebra. But businesses do still have a default, everybody can see everything. This shouldn't be the case. It comes from sort of data protection, data management more generally, but the principle of minimum access is what should be thought about and applied here. And what this means in practice is locking down data, save for the relevant project team. What this means from a security perspective is that if an attacker does get access to your network, they can't simply move laterally across shared network drives and access and exfiltrate whatever they want. If you've got access controls and lock down certain network drives, that does restrict their ability to get access and move across the network and exfiltrate more data. One point on here as well that I haven't put on the slide is thinking about encryption. Encryption of any valuable data at rest now is becoming standard practice. Encryption in transit is more difficult, it's more CPU intensive and can slow things down quite a bit. So that's one to think about whether it's practical for the data in question. And obviously if data is in use on a continual basis, then encryption isn't really an option. But if you do have data which falls within that category, think about access management and also access logging so that you can always see who's accessed the data, when they've accessed the data, if there is an issue later on. I talked a bit about staff training. One of the key things here really is around phishing. Phishing is still incredibly successful, depressingly effective. This falls really into two categories. The first is Nigerian princes with $10 million that they want to get out of the country. If only your employees will click on this link to give them your bank details. That's less of a risk, really. I would hope that intelligent people working for you don't believe that bags of cash fall out of the sky and get handed over to them. The real threat here is targeted phishing. And this is well-created phishing emails aimed at the person in question, having done a bit of research around social media, LinkedIn, etc., so they look more believable. And in reality, what's going on here is these emails are hacking the human, not the computer. It's the sort of language sometimes used. And one good way to think about this is actually considering the characteristics of key staff who have access to the high-risk data. And what are they likely to fall for? And this is around social engineering. So one way of working on your security posture and reducing risk around phishing is sort of training to the traits of your staff that make them higher risk. And in a life sciences organization, this might be, putting aside the sort of board and execs on the financial side, it might be your scientists, your engineers. So having a think about what pushes their buttons, when are they most vulnerable, what are they most likely to respond to, and then actually helping them to understand their blind spots or potential weaknesses that means they're more likely to fall for phishing emails. I've referred to link scanning on the slide, and Mimecast is good. Other tools are available, obviously, and this is just automated systems that scan any link that comes through on an email that somebody tries to click on, validates it as a good link or a bad link. They're never 100% successful, but they are very, very, very good at minimizing the risk of phishing attacks. They obviously don't work with attachments, so some form of attachment scanning system is also a good idea. One other thing to think about here, which is becoming more common practice, I wouldn't say it's standard practice yet, but it's happening more and more, is sending fake phishing emails around the business, seeing who clicks on them. If somebody does fall for them, they get a prize of extra training, but also monitoring that, seeing are your rates of staff who fall for the fake phishing emails falling over time. If not, is your training good? Is it appropriate? Is it achieving what you want it to achieve? And another point here is where external emails come into the organization, you can set rules in Outlook at a server level to put a nice big bit of red text at the top of an email saying this email has come from an external source, be careful, sort of thing. And that's a useful flag as a sort of warning to people. I've referred to MFA, multi-factor authentication for any cloud systems. We are seeing a huge amount of attacks around Office 365 and Google Drive and things, which are aimed at credential harvesting. The attackers then log in, exfiltrate first the most recent 6 months of emails from the mailbox, and then if they've got time, they go back further. And this has been validated and confirmed by the NCSC as what they're seeing in terms of activity on this. And they then basically go through that data and see what they can use to try and monetize it. And that could be anything from invoice fraud, hi, you haven't paid our invoice, here's a reminder invoice which changes the bank details, through to actually then, after attackers have been found and kicked off a network, setting up a spoof email address for an employee, replying to a legitimate chain of emails that's been a discussion within the business from the spoof email address, but making it look as though it's from a legitimate employee. That's then got another document with malware attached, and that's a good way of reinfecting somebody's system. And there's a whole raft of things in between, simple sale of data, etc., which happens with that kind of thing. So multi-factor is a really, really important thing. If you are moving to cloud, remote access, anything like that, to be honest, multi-factor is a must now. I've got a number of other points I did want to talk about here, but just in the interest of time, we might pass on those for now and might add a couple more slides on and circulate those around afterwards if anybody else is interested. Hopefully that was a useful run through some of the risks that we are seeing in practice and some of the things that you can do to mitigate those risks and risks around cybersecurity for life sciences companies. We do have a couple of questions, so I think we'll turn quickly to those. The first question is, what level of maturity do you see from life sciences clients in having specific suites of contractual cyber clauses to address and mitigate some of these risks, e.g. specific definitions of cyber attack or security incident with specific consequences around termination, force majeure, audit rights, remediation plans, separate liability regimes, etc.? Which is a very good question. I think Vin was going to comment first on that.
Yes, so this is an interesting question, and I think the answer to it largely is driven by, I guess, what period of time are we talking about? Because we're seeing an evolution not only in the law, but we're seeing an evolution in the way in which organisations are perhaps becoming better prepared in this area. So if I was to say the answer to this question looking back, say, 2 years, I'd say the level of maturity is probably low, and at best low to medium. If I'm saying more recently, I think actually in many ways it's probably moving up to in sort of RAG rating terms, maybe even medium to high in some cases. So definitely we're looking at sort of amber or green ratings as we're seeing more and more often. But certainly over the last 2 years we've seen a lot of low to medium type of representation in this area. So what do I mean by that? I think in my experience, going back 2, 3, 4 years, there just wasn't the emphasis to focus on data, information, the threat environment around it, and actually really manipulate that and express it into contractual clauses. What we saw were broad references around this area, but actually not a lot of depth around what that meant, not a lot of depth around the linkage between the different types of, different aspects of a contract and the consequences, etc. But we are seeing that change, and we are seeing that shift, and I think the reason we're seeing that shift is because, and I would put it down as a GDPR practitioner, I'd put it down to the fact that GDPR has forced organisations to think about what data they hold. Not guess, not estimate or guesstimate, but actually assess what they hold, document that, and really understand it, and then map that against the purposes and risks and so on. So when you look at the application of GDPR and you start to see that there is an increasing or a better understanding of what data has been held, and then you see the other aspects of GDPR compliance such as record or processing activities, or more importantly, maturity in techniques such as privacy impact assessment. In other words, where organisations go further than simply recognising and understanding what data they have, but genuinely in a more mature way assessing why they have it, what the risks are to the data. That's what we're seeing also being represented in some of the more recent contractual clauses and mechanisms that we're seeing, where it's not necessarily the case that we just see that broad term around data or security or incidents, but actually something a little bit more specific, something that's more tailored to the activity under the contract, tailored to the data processing that's going to take place under the contract, tailored to the role of the parties under those agreements. And I think that's the biggest shift that we're beginning to see. I think we're only just beginning to see it, but we are seeing it. And I don't think there's a standard position on the way in which the consequences of that link to clauses such as termination and force majeure. I think in some cases we are seeing a move towards a specific linkage, and that's that shift that we're seeing. But I think what we're seeing more importantly than that is actually not just provisions that begin to say this is what we recognise as an actual or suspected incident, but this is what we now think you should do when that particular event has been triggered. And the sophistication is beginning to flow around the consequence. In other words, notify us, and notify us within a certain period. Stop doing this or do that. So we're seeing much more around that. And I think also that links to a lot of what Paul mentioned on his latter slides, because more and more organisations are not only gearing up towards the implementation of GDPR in a more meaningful way, but actually as we begin to see more organisations mature out from GDPR programs and start to reassess their data security readiness. And so you're forearmed with all of that, and then start to see, well, how does this manifest itself into contractual flow downs? So in short, I think the maturity level has been fairly low in the past, but we are seeing that shift.
And just quickly on that, I mean, Vincent referred to GDPR quite a bit. I think that has driven a shift in behaviour because of the potential ramifications of getting it wrong. What we have seen more of is around audit rights to security ability and sort of contractual remediation plans that follow for failures. Termination is less common still. It's more sort of agreeing a roadmap for remediation. Separate liability regimes we're absolutely seeing more and more of, which is that liability for data breaches are more often carved out of or are subject to a higher cap than the standard contractual limitation of liability cap. So the second question that we had is, what guidance do you have in relation to privilege for global crisis teams, e.g. spanning the UK, US, India and China, particularly when teams are using informal comms, e.g. IM, text or even WhatsApp? And Jessie was going to pick up a point on this first, and then I'll comment more generally.
Yeah, so just quickly on that, it's an interesting question about, this really comes down to the definition of client, both for litigation privilege and legal advice privilege. Now also, of course, with litigation privilege, it covers communications between lawyers, clients and third parties, and those third parties can include employees within the organisation if they're providing information towards the contemplated litigation. However, where the client is, or where the employees would really be coming within the definition of client, the important point to assert privilege is to define all those people who are going to be receiving or obtaining advice to come within the definition of client. At the same time, we would be suggesting, as the law stands at present, that the definition or that the number of people who are the client is kept as small as possible, because it assists in meaning that you don't have waiver of privilege. But if it is a bigger group, you should define it. The other thing I would just mention, the case I was talking about, SFO and ENRC, the Court of Appeal didn't reverse the decision on legal advice privilege, which those who were involved with the case, well, and on the appellant side, I know were disappointed about, and are very keen to take to the Supreme Court the definition of client, particularly bearing in mind the legal advice privilege context, because it is very narrow from the Three Rivers decision, and it does mean that in global organisations where many people need to be involved in an incident such as this, it causes real practical difficulties. So there is an appetite to try and challenge the definition of client as it stands for legal advice privilege purposes, particularly if someone has the appetite to do so.
And just on a more macro level on this question, because it does come up fairly often in data breaches, because obviously they tend to be international in nature. There's a couple of points really. One is about understanding what the risk around privilege is in the different jurisdictions in question, and how those jurisdictions deal with privilege under national law. Therefore, what is the risk of waiver of privilege, and understanding your sort of lowest common denominator, basically. So what are the jurisdictions where you have the highest risk of loss of privilege? And it then becomes a question of sort of information flow management to a large degree. And it may be that for the jurisdictions which are higher risk for loss of privilege, that actually they receive less, those in the jurisdictions dealing with the information receive less information, or the information flows very much from that jurisdiction to those managing the information internationally, so that you limit the risk of waiver more broadly, but also you have a better argument that if there is a risk of waiver of privilege, it is in the jurisdiction, it is limited to that jurisdiction, which has the higher risk of loss of waiver than others. And just on the point on informal comms, referring to IM text, even WhatsApp, it's actually quite an apposite question for data for cybersecurity issues, and I've had several matters where we've ended up advising the client over WhatsApp because the client wasn't certain of the security of their own systems. Really the risk here is around the fact that it's an informal communications channel, so people tend to be less guarded in what they say. There's no specific issue arising out of using those channels as opposed to, for example, email, other than that informality of communication. It's still disclosable in the same way if you do end up in the area where privilege has been waived. So it's really about understanding what is the information which you need to manage, how do you need to manage that information in relation to certain jurisdictions, and really having a good understanding at the start what the risk attaching to your higher privilege risk jurisdictions is, and trying to minimize the risk of loss of privilege in those jurisdictions. We've run out of time. We picked sort of the two questions that were hopefully sort of most use to people. Just so please do keep an eye out for the next webinars in the series, which will be focused, I think, on more traditional issues for disputes around life sciences companies. We thought we'd pick a slightly off the wall one as the first one. If you are interested in some of the issues we touched on today, please do get in touch. And if you're not already on the mailing lists or checking sign-ups around life sciences issues, which is the publication that we put out specifically for the life sciences industry, or our global data hub, which is the more data protection focused content that we push out, please do get in touch and we can make sure that you are added to those lists. Thank you very much for dialing in, everybody, and we hope you found it useful.